some of the legal duties that are relevant here. What duty of care applies to employers for those with mental health issues? I think it's useful for us to put some legal context here.
Well, all employers have a duty to take reasonable care for the health of their employees, and that applies at common law. And all employers also have a statutory duty to not only ensure reasonable care for the health of employees, but to ensure that there's a safe place of work. And that safe place of work can involve protecting employees against stress-related illness. Two elements of that legal duty. What must the employer do? Well, the employer's got a duty to undertake suitable and sufficient risk assessments. And Steve from our health and safety arm is here today and has significant expertise in risk assessments. And once those risk assessments have been undertaken, the employer needs to apply what are called principles of prevention. And those principles of prevention entail avoiding risks, combating risks at source, developing an overall coherent policy which covers technology, the organisation generally, social relationships for protecting individuals against mental health difficulties, and providing them with appropriate information. So we've talked about signposting, and we've talked about stress policies or wellbeing policies as they're called in some organisations. So in addition to that general duty of care, I suppose within the duty of care question you've got potential legal pitfalls like unfair dismissal, if a dismissal ultimately happens in consequence of either long-term absence or a series of short-term absences. Disability discrimination is just about the most complex area of employment law that I'm aware of, and I'm sure there'll be some questions on disability discrimination later on and possibly from the audience. And also even harassment. Employees who believe that they have been subject to harassment at work have a potential right of action under a piece of legislation called the Protection from Harassment Act. Uncommon for that piece of legislation to be utilised, but there is a duty of care under that legislation nonetheless. So those are the main areas in which employers have a duty of care.
So the ones that people particularly worry about, probably in the context of today, will be around disability, I think. Unfair dismissal to an extent, but disability especially.
Yeah.
So when will it be a disability? And what difference would that actually make?
Yeah. Well, a disability has a very precise legal meaning under the Equality Act. What disability means under the Equality Act isn't what it means in the general day-to-day use of language. A disability under the Equality Act is where an individual has a physical or mental impairment which has a substantial and long-term adverse effect on ability to carry out day-to-day activities. Now, all of those things can be broadly broken down, but a mental impairment can be anxiety, can be depression, can be a whole plethora of impairments. There's an interesting issue around whether someone is potentially disabled if they're not prepared to engage with, for example, a grievance process at work. Because very often employers worry about whether someone who is behaving in that way is disabled. Most of the time they won't be, but you would require a careful analysis of the medical evidence to determine that question. The focus really though is on whether an individual can or can only with difficulty perform normal day-to-day activities. And normal day-to-day activities, as the name implied, it can be any activity which an impairment means that they can't perform.
So not their job activities?
Not their job activities, any normal day-to-day activities. And the thing to remember... So
just to clarify that, your job activities might be sitting in an office writing, they might be out on a building site, but the question is whether you can do obvious things like make your bed, have a cup of tea, etc., etc. Those are the...
And it could be some components of the job. For example, writing would be a normal day-to-day activity. But the thing to remember is that being disabled under the Equality Act isn't an automatic right to compensation. It's simply a gateway into a suite of rights effectively not to be discriminated against. So a further point that I'm often asked is, well, we didn't cause this this disability. Cause is irrelevant. Being disabled is really just a gateway to a set of rights. And of course, if someone is disabled within the meaning of the Equality Act, the main obligation that most employers are aware of in principle, but not necessarily the details, is an obligation to make reasonable adjustments. And so in consequence, your question, how does that change things? If an individual is disabled, an employer can fall under a duty to make reasonable adjustments to a whole, well, pretty much any what's called provision, criterion or practice which exists at work. And I rather suspect, I may be wrong, but there may be some sub-questions around